Hello, I'm Ajat Ahmed. I'm a visiting faculty at OP Jindal Global University. The module is about judiciary and HIV/AIDS. Let's look at the intended learning outcomes of the module. By the end of this module, the reader shall be able to understand the challenges confronting the people living with HIV and those vulnerable to HIV, to analyze the role of judiciary in protecting the rights of people living with HIV. Courts in India and abroad have passed numerous judgments relating to human rights of people living with or affected by HIV. Case laws in the context of HIV deal with certain specific issues like discrimination, consent, public health, and confidentiality affecting the people living with HIV. As there is no specific statute to address the issues arising in the context of HIV in India, courts had to look into a variety of sources of law to make their decisions. Some of the prominent judgments pertaining to certain identified critical issues facing persons infected with HIV are discussed below. Look at public health. HIV and AIDS pose a major public health challenge. People living with HIV face numerous hurdles in accessing prevention, treatment, and care services. While the major constraint continues to be stigma and discrimination, states need to also scale up its efforts to provide affordable treatment to its people. Lucy R. D. Souza versus State of Goa, Bombay High Court, AIR 1990, PM 355. The first HIV litigation arose in the country when Dominique De Souza, an HIV positive activist, was incarcerated on being found in HIV positive. A blood test was conducted on him without the knowledge or consent, and the donated blood and his HIV positive status was revealed to the police and not him. The police subsequently arrested under the Goa Daman and Diu Public Health Act 1985 and put him in an unused TB sanctorum. An amendment to the act had authorized the state to mandatorily test any person for HIV and isolate them on being tested HIV positive. Dominique's mother approached the Bombay High Court challenging the said provision as violative of her son's fundamental rights. While recognizing that isolation has several serious consequences, the court held that individual rights have to balance public interests, and if there is a conflict between the rights of an individual and public interest, the former must yield to the latter. The Sankalp Rehabilitation Trust versus Union of India, Supreme Court of India, WPC number 512 of 1999. In 1999, a public interest litigation was filed in the Supreme Court of India by Lawyers Collective through the Sankalp Rehabilitation Trust, Mumbai, to address the barriers faced by people living with HIV in accessing the healthcare services, especially the discrimination they face in hospitals. With the passing of significant orders, this PIL was until recently used as an oversight mechanism for the National Antiretroviral ARV rollout program, and a number of issues pertaining to access to treatment has been addressed through this. Major orders including ensuring second line of ARV treatment to all the people living with HIV who need it irrespective of other criteria, thereby ensuring universal access to treatment, ensuring adequate infrastructure in antiretroviral therapy centers, creation of a grievance redressal mechanism, rapid upscale of ART centers, and link ART centers, requiring all private doctors to follow NACO's protocol while prescribing ARVs, etc. Voluntary Health Association of Punjab, VHAP, versus the Union of India and ORS, Supreme Court of India, WP Civil number 311 of 2003. In 2003, Human Rights Law Network, an NGO, filed a petition in the Supreme Court of India through Voluntary Health Association of Punjab seeking provision of free ARV drugs to HIV positive people. The petitioner sought recognition and implementation of the right to health and treatment of HIV positive persons as a part of their right to life under Article 21 of the Indian Constitution. As a part response to this petition, the government announced free ARV drugs for 100,000 people in 6 high prevalence states and committed to provide treatment to an additional 15 to 20% of AIDS cases each year. Thereafter, for a period of 5 years, however, ground realities demonstrated that these commitments were not fulfilled. In 2006, court asked the central government to explain its position and to explain why it had failed on its commitment. Numerous directions for ensuring access to ARV drugs to HIV positive people were issued in this case. Next case is the Subodh Sharma and ANR versus State of Assam and ORS, Guwahati High Court, 2000. In this case, the petitioners raised the grievance of non-utilization of funds allocated for the HIV/AIDS project. They contended that an AIDS control society was yet to be set up in the state, and there also needs to be check on whether there has been proper utilization of funds in phase 1 and phase 2 of the project. Further contentions included constitution of a monitoring committee with substantial representation from NGOs. There be no delay in release of the funds, and the funds so released be not diverted to other heads of account. Appointing persons having adequate experience in the field of healthcare and control of diseases in the State AIDS Control Society instead of IAS officers, and ensuring proper facilities for HIV testing. The respondents submitted that all possible steps prescribed by medical science were being undertaken by the state's AIDS cell, and there were only few stray incidences of isolation of HIV positive patients. But the cell did not have administrative control and therefore could not make any direct intervention in the matter. The funds released, although at a belated stage, have been properly utilized and audited. The court, however, found that despite being aware of the urgent necessity to deal with the problem, the state of Assam has not been able to gear up its machineries to the extent necessary, and most of the contentions of the petitioners were found to be true. Due to the drawbacks in implementation of the programs, court passed several directions, including ensuring proper implementation of guidelines and strategies formulated by NACO by the state, assuring non-diversion of funds provided by Government of India, making proper inquiry into the irregularities in funding affairs, and take appropriate action by the state, closing of unlicensed blood banks, evolving of effective monitoring systems, opening of AIDS counseling centers, and appropriate orders or directives to be issued to ensure that persons suspected to be suffering from AIDS or HIV positive shall not be refused treatment in the hospitals. One can also see cases like Ram at Ramdas R. Ubale versus State of Maharashtra, Bombay High Court Criminal Application 371 of 2008 in Appeal number 706 of 2006, M. Vijay versus Chairman and MD Singareni, Collieries Company Limited, HYD and ORS 2001, 5 ILD. Now looking at consent for testing and treatment. Often violated in the context of HIV is the informed consent of people living with HIV and vulnerable to HIV for testing and treatment Mandatory testing of individuals is detrimental to effectively combat HIV. Patients have a right to have knowledge and information of the options available, along with benefits and risks involved in treatment, and medical practitioners have a duty to take informed consent from the patients. There are only few cases dealing with consent for testing and treatment in HIV. The concept of informed consent is not fully developed in India. Generally, it has been recognized in England, United States, Canada, and Australia that doctor, as part of duty of care, has a duty to take informed consent for treatment. However, the standards on the specificities of informed consent, that's how much information and what kind of risks should be disclosed to the patient, vary slightly across these jurisdictions. In England, doctor has the duty to warn of risks of such misfortune inherent in procedure. However, it's carried out. However, this duty does not extend to unforeseeable risks like Chatterton versus Gerson 1981, 1 All ER 257. In United States, doctors must disclose all material risks. A risk in material when a reasonable person in what the physician knows to be the patient's position would attach significance to the risk. The case of Canterbury versus Spencer 1972. Law in Canada connects the rights and duties of born doctors and patients and requires them to consider both objective and subjective factors. Objective factors are those which a reasonable patient would complain of, and subjective factors are the particular concerns and special consideration affecting a particular patient. The latter would help decide if the patient would have refused treatment had he or she been informed of the possible risks. The case of Margaret Smith versus Carol Arndt and Dennis Jackson 1997 to SCR 539. In spite of these standards in place, the regressive policy of mandatory screening is upheld by courts in many instances. One such case is given below. The State versus Wallace 2005, Ohio, APP Lexus 1808. Wallace was indicted on counts of solicitation RC 2007 and loitering to engage in solicitation. After a positive HIV test, the Montgomery County Court of Common Pleas ordered him to undergo testing for sexually transmitted diseases pursuant to RC 2907.27. He went on appeal contending that the statute is unconstitutional because the testing constitutes an invasion of his privacy and also a violation of due process. The Court of Appeals of Ohio, 2nd Appellate District, Montgomery County, held that RC 2907.27, which permits the warrantless testing of persons charged with violations of RC 200724 and RC 2907.241 with regards to treatment for persons who test positive, does not violate the protections against unreasonable search as set forth in the Fourth Amendment to the United States Constitution and Section 14, Article 1 of the Ohio Constitution, because it's reasonably related to a special government need to protect the public from the spread of sexually transmitted diseases. Now let's look at the question of confidentiality. Human right norms of autonomy and respect for privacy demand that a person should be given right to keep his or her HIV status confidential. It's also crucial for encouraging those at the risk of HIV to come forward and access prevention, care, and treatment services. Courts have upheld the right to confidentiality of persons living with HIV by maintaining a balance between the interests to maintain confidentiality and disclosure. The case of Jeffrey versus M.I. Tadlock and Keeney et al., 2085, California, APP 434. In this case, the petitioner sued a law firm for disclosure of his medical records relating to HIV status as violation of his right to privacy. The court found that the documents disclosing appellant's HIV status had been improperly copied from medical records of the hospital and disclosed by the law firm, even after knowing its legally protected confidentiality status. It also noted an earlier judgment where it was held that the unauthorized disclosure of HIV positive test results undermines the public interest in encouraging patients to submit to HIV testing and to make needed disclosures of HIV positive status during medical treatment. XVY 1984 to all ER 414 QBD England. A newspaper came to know about the HIV status of two practicing doctors of a hospital. Though the hospital obtained an injunction order restraining the newspaper from using the confidential information, the newspaper went ahead and published an article titled "Scandal of Docs with AIDS." It also noted that in a further article, the names of the doctors would be revealed. Hospital approached the court, claiming contempt and requested further injunction from disclosure of the names of doctors, and also information regarding the source of information. Granting injunction, the court said that disclosure of names was not necessary for any informed debate on the issue. It also convicted the newspaper for contempt as it has published the article despite the injunction being in place. However, the court declined the request for disclosure of source. Another case is Mr. X v. Hospital Z, AIR 1998, SCW 3662. In this case, X, a doctor whose HIV positive status was disclosed by hospital authorities to a third person, approached the Supreme Court of India. X had called off his marriage on knowing that he was HIV positive, but the disclosure of information had resulted in him being severely ostracized by the community. The Supreme Court held that though confidentiality is an important part of medical ethics, public interest would override confidentiality, particularly when there is an immediate or future health risk to others. It also held that failure of the hospital authorities to disclose this information would have made them participant criminals. However, what became controversial was this ruling that the right to marry was a suspended right for a person living with HIV. Another case is, an example is Mr. X v. Hospital, AR 2003 SCC 664. Discrimination. Now let's look at discrimination. Persons infected or affected by HIV are subjected to discrimination on multiple grounds. These include discrimination in the fields of employment, education, healthcare, subjecting to mandatory testing, etc. Following are some landmark cases pertaining to discrimination of people living with HIV. For example, the Bragdon versus Abbott, 524 U.S. 624, 1998. Abbott, an HIV positive person, was denied treatment by Bragdon, a private dentist, at his office. Aggrieved by this, Abbott filed a suit in the federal trial court under the Americans with Disabilities Act 1990, which he won. On appeal, the United States Supreme Court held that HIV was an impairment which substantially limits reproduction, and reproduction is a major life activity under ADA. A healthcare professional could refuse treatment only in cases of the patient posing a significant risk to the health and safety of others that cannot be eliminated by a modification of policies, practices, or procedures, or by the provision of auxiliary aids or services. And this has to be determined from the standpoint of the person who refuses the treatment or accommodation on the basis of medical or other objective evidence. evidence and not on the belief of risk. Another case is of Chalk versus United States District Court, Central District 1987, F2D 701. In this case, a school teacher was barred from classroom and reassigned to an administrative position when she was found to be HIV positive. The court here held on U.S. Supreme Court's decision in School Board of Nassau County versus Airline 480 U.S. 273 dated 1987, wherein it was held that a handicapped person as per the Rehabilitation Act, if otherwise qualified as fit to perform his or her job and posing no substantial risk of transmission after reasonable accommodation, cannot be discriminated against in the matters of employment. The court, after applying the four-pronged test provided in the airline case and weighing the hardships faced by the employer and employee, held that Chalk need not disprove any theoretical possibility of harm. Chalk was at risk of irreparable injury to his livelihood, and the injury to Chalk would outweigh any harm to the school. Another case is that of Hoffman versus South African Airways CCT 17/00. Whether the practice of South African Airways to refuse employing people living with HIV as cabin attendants was constitutionally valid was the question facing the Constitutional Court of South Africa in this case. While the High Court had earlier dismissed the petition stating that the Airways practice was based on medical necessity, safety, and operational procedure, the Constitutional Court held that the denial of employment to the appellant on the grounds that he was living with HIV amounted to unfair discrimination under Section 9 of the South African Constitution. The legitimate commercial interests of the respondent, although important, cannot be allowed to justify unwarranted prejudice and stereotyping, stating that people living with HIV are a vulnerable minority treated with intense prejudice by the society and subjected to disadvantage, stigmatization, and marginalization, and that impact, especially in the field of employment, can be devastating, since it denies them a right to living and condemns them to economic death. The court directed instatement of the appellant from the day of court order. Another case is that of MX of Bombay, Indian inhabitant versus MSZY and ANR, AIR 1997, BOM 406. In this landmark case, the Bombay High Court considered the question whether a person who has been tested positive for HIV can lawfully and justifiably be rendered medically unfit, solely on that ground so as to deny him the employment. MX, a casual laborer, was tested for HIV prior to his regularization of job by his employee ZY, a public sector corporation. Though otherwise fit, he was found to be HIV positive and therefore rejected from regularization, and his contract was terminated. MX challenged his termination and also the circulars issued by the corporation, making HIV tests mandatory for pre-confirmation. He argued that these violated Article 14, right to equality, Article 16, right to non-discrimination in state employment, and Article 21, right to life of the Indian Constitution. In this case, the court held that no person can be deprived of his right to livelihood except according to the procedure established by law, and such procedure has to be just, fair, and reasonable. Accordingly, it held that a person who, though has some ailment, cannot be denied employment if he is otherwise qualified, capable of performing normal job functions, and does not pose a substantial risk to others at the workplace during his normal activities. determining whether a person is unfit or incapable of performing the job is a question of fact, which should be determined not merely on the basis of a medical test but also by a competent medical expert. Court found MX dismissal to be arbitrary, unjust, and unlawful, and also held that a public sector employer cannot deny a person employment solely because the person is HIV positive. Let's now summarize. There's evidence signifying that litigation, when done in a coordinated, structured, and repeated fashion, has the potential for creating a culture of rights consciousness within a society. From the above discussion, we have seen that most of the complex situations which arose in the context of HIV/AIDS has been dealt by the judiciary. People infected and affected by HIV, as well as human rights advocates, have knocked the doors of judiciary whenever there has been a violation of rights. Well, it's encouraging that the judiciary has taken a preeminent role in defining the HIV jurisprudence. The concern remains that juridical interpretations finally depend on the individual predilections of the judges. The right to marry case is a telling example of the uncertainty binding the situation. Adding on to the inconsistencies in judicial pronouncements are the delays entrenching the judicial process. Needless to say, without effective legislative mechanisms in place, there are only limited options available to the aggrieved persons. We come to the end of the module. Thank you very much.